Today on Law Weekly, we look at the debate on the need for specialized courts to try corruption cases. Some stakeholders in the justice sector share their thoughts on this issue. On our interview segment, Senior Advocate of Nigeria, Mr. Lai Babatunde, speaks to Law Weekly about the administration of justice with particular emphasis on the need for better and regular training of judges. All that and more on this episode of Law Weekly on Channels Television. Hello and welcome. I am Shola Shoyeli. The much talked about war against graft has again brought to the fore the discussion on whether the country needs special courts to try graft cases. Some respondents who spoke to Law Weekly are not quite agreed on the need for the courts, but they all agreed that there needs to be more emphasis on the quality of the bench.
What the government should concentrate on is to strengthen the existing courts and then make life comfortable for the judges. And then most importantly, I think government should pay attention or should liaise with the National Assembly towards amending Section 292 of the 1999 Constitution, which says that any person who has been a judicial officer, on ceasing to be a judicial officer, shall not practice as a legal practitioner in Nigeria. In other words, that section removes the power from a judge who in the first place was a lawyer before becoming a judge from practicing on ceasing from becoming a judge. It will give the judges the power to act independently, believing that as soon as they take any action that is not in tandem with the position of government, and that even if they are removed as judges, they can fall back on their certificate as lawyers and practice. It will give them a sense of independence. Even if you establish so many courts and they don't have the power, the strength, the latitude to ventilate, they will not give their best.
No, there can hardly be a problem with judges. The reason being that, look, in my opinion, I believe that the judges are overworked, no matter how you look at it. So if special courts are going to be set up, my first thinking would be that, fine, sitting judges are probably will form the nucleus for such a specialized area, and then new judges will be appointed, most definitely. So I think it would be better for the system, really.
In other crimes, common law jurisdictions, there are no special courts set up for corruption cases alone. So I don't think we need that.
In as much as setting up special courts may help us out of all this problem, but we should also be careful so as we do not bastardize the whole essence of the special courts. Because when you are setting up are you setting up special courts in all the states? Or is this a federal concern or state concern? Who are the judges that will run the courts? So we need to know to set our priorities right, in fighting, because there are a number of ways by which we can actually fight this corruption. And setting up a special court is one of them. Then the anti-corruption agencies also need to be, strengthened. Maybe probably by merging. I even, there was a time people were saying that ICPC and EFCC should be merged, so as we have, a better and more efficient anti-corruption organ. So we should not, say because we want to fight corruption, and at the end of the day, we ended up, creating more problems for ourselves than we are trying to solve. So if you are trying to set up special courts, we must get our priorities right. Who are the judges? If the judges are to be, federal judges, so the federal government will take care of you. Because when you are setting up corruption courts in states, and governors are now appointing judges, you know what will happen. But if the federal government say, okay, if this thing is federal concern, then we know that federal government will appoint judges, and then we can be rest assured that the judges will perform. So we must set our priorities right.
The main issue is not creating courts to tackle corruption, but fighting the root of corruption. And fighting the root of corruption, government has a part to play. The part government has to play is, first and foremost, providing enough for the citizenry. Imagine a situation where minimum wage is 18,000 naira. The people receiving 18,000 naira as minimum wage procreate like the ministers and the presidents and every other person. In fact, some of them procreate more than the ministers. In a situation like that, what do you think will happen? Is it with the 18,000 naira it will provide for the number of children it has, provide for every other thing? It's not possible. Government has to look at the salary level of every citizen or of every worker. Create other areas where people will be empowered financially. Once the people are fully empowered or sufficiently empowered, I think they will not remember going back to corruption. That is what I want the government to do, and not by creating courts.
Welcome back. Last week, the high-profile trial of some bankers on allegations of recycling of mutilated currency notes commenced with an arraignment at the Federal High Court in Ibadan, the Oyo State capital. It's a case that will follow closely, but we have the recap of what transpired last week, as well as some other top legal stories.
The Economic and Financial Crimes Commission, the EFCC, last week Thursday arraigned 5 accused persons, the last batch in the hearing of the suits on the Central Bank of Nigeria's 8 billion naira mutilated currency fraud. The Economic and Financial Crimes Commission told Justice Adeyinka Faji that the accused persons conspired with other suspects now at large between 2011 and 2012 in Ibadan and tricked the CBN to pay out large sums of money in exchange for the proposed returned mutilated currency notes. Arrangements of the accused persons in the suit began last week Tuesday, and by Thursday, 22 bank officials had already been brought to the court, who ordered their remand in prison custody. Justice Faaj has fixed June the 12th for hearing in their bail application. And from the court in Ibadan, we move to the Federal High Court in Abuja, where the federal government last week asked Justice Evochukwu to terminate further hearing on the 6-count criminal charge preferred against the former governor of Bayelsa State, Mr. Timothy Silva, by the Economic and Financial Crimes Commission, the EFCC. The directive came on the day the court had fixed for the anti-graft agency to call witnesses and tender exhibits against the ex-governor, who was accused of masterminding the illegal diversion of funds from the Bayelsa State Treasury while he was in power. He was specifically accused of siphoning over 6.5 billion naira from the Bayelsa State Treasury between October 2009 and February 2010. With the withdrawal of the charge, the former governor, through his lawyer, immediately asked for the release of his passport and other travel documents. The court struck out the suit and ordered the release of the documents. And from the court in Abuja to the Federal High Court in Lagos, the contempt proceedings instituted by the Senator-elect of Ogun East Senatorial District, Mr. Buruji Kashamu, against the Attorney General of the Federation and the Chairman of the National Drug Law Enforcement Agency, was told last week Friday. Lawyers representing the NDLEA and the Attorney General of the Federation asked for more time to file their responses to the suit. The trial judge, Justice Ibrahim Buba, had to adjourn the hearing of the contempt proceedings to June the 19th. Before fixing the date, however, Justice Buba ordered that all the parties in the matter must not do anything to undermine the process and the authority of the court. Meanwhile, the NDLEA has filed an application to challenge the jurisdiction of the court to entertain the suit, and has also filed a motion seeking to set aside the court's earlier order barring the moves to extradite Mr. Kashamu to the US to face the charges against him. Barring the moves to extradite Mr. Kashamu to the US to face the charges against him. And at the Lagos High Court sitting in Ikeja, the coroner probing the collapse of the building belonging to the Synagogue Church of All Nations last week, Tuesday, fixed July the 8th, for adjournment on the inquest. Magistrate Oyetade Komolafe, who had been presiding over the inquest in the last 8 months, fixed the date after all the parties in the proceeding adopted their final written submissions. The Lagos State government has set up the inquest under the State Coroner System, Law No. 7 of 2007, to investigate the cause and circumstances of the collapsed building which resulted in the death of 116 people, mostly foreigners. However, in spite of repeated summons issued on him by the coroner, the founder of the church, Prophet T.B. Joshua, refused to appear before the inquest. And we round off on the foreign scene with news that an Egyptian court last week, Thursday, adjourned the retrial of Al Jazeera television journalist to June the 11th for more closing statements by the defense team. The journalists were charged with aiding a terrorist organization, a reference to the Muslim Brotherhood, which was outlawed in Egypt after the army ousted Islamist President Mohamed Morsi amidst mass protests against his rule in 2013. Mohamed Fahmy, a naturalized Canadian who gave up his Egyptian citizenship, and Egyptian Behar Mohammed were released on bail in February after spending over a year in custody. A third Al Jazeera journalist, Australian Peter Grast, was deported in February. The journalists were originally sentenced to between 7 and 10 years in prison on charges including spreading lies to help a terrorist organization, charges which they have denied.
And now to our interview segment. My guest, Mr. Lai Babatunde, was conferred with the rank of Senior Advocate of Nigeria in 2004. He's also the Editor-in-Chief and Chief Executive Officer of Lawbreed Limited, publishers of judgments of the Supreme Court. He has also authored other law publications from civil to criminal law and procedure and even land law, to mention a few. In this interview, we talk about some reforms that should happen in the justice sector. He particularly thinks that judges should get regular and quality training to enable them manage their courts better.